Yesterday, over 200 women's groups laid siege on Nigeria's federal legislature in Abuja to protest the rejection of all gender-related bills during voting the day before on the fifth alteration of the 1999 Constitution. As a mark of their displeasure, the protesters were joined by some female lawmakers who refused to join their male colleagues in plenary. Similarly, some civil society organizations kicked against the retention of the immunity clause for the president and governors in the Constitution, saying it should have been deleted in line with the wishes of the people. Despite the protest of the 68 bills seeking to amend the Constitution, 46 got the yes vote of both chambers of the National Assembly. Now joining us from Abuja to take a granular look at some of the major bills that got the nod of both houses and those that were rejected is Femi Falana, a senior advocate of Nigeria, popular social critic, and civil rights activist. Good morning, Mr. Falana, and thank you for joining us. Well, okay, the matter is already placed before you. Good morning,
Dr. Ruben.
Yes, the matter is already placed before you. This fifth alteration of the Constitution, how far-reaching do you think it is? Particularly as some persons have argued that this doesn't amount to any kind of advancement or restructuring, and that is just a cosmetic activity. And you wrote an essay this week on making Chapter 2 of the 1999 Constitution justiciable. And some of the issues raised, particularly with regard to citizenship, indigenship, are covered under that Chapter 2 of the Constitution. If you may speak to these, two issues.
Well, I think what the National Assembly is doing, once again, is to engage in instrumental amendments of certain provisions of the Constitution, which at the end of the day can be likened to movement without any progress being recorded. In 2014, the amendments were not even allowed to be passed. I think the regime then rushed to court to stop the amendment when we had spent a colossal sum of money. At the end of the day, if you are going to be told what we have spent on this exercise again, you'll be amazed. And you ask yourself, what do these amendments amount to? Once you are consolidating the politics of exclusion. I mean, you have women who are not less than 50% of the population. You are simply saying they do not matter. You have the youths that constitute about 60% of the voting population. You are saying you are irrelevant. You have people with disabilities who are not less than 20 million in the country. They are not taken into cognizance. And then you say you are amending the Constitution. When you look at the totality of the amendments, you will discover that there is nothing really that no provision has been made to address insecurity in our country. The collapse of the economy. So what have they done other than to say, we are passing a bill, want to entrench a clause to allow virtual hearing in the courts? I beg your pardon. The courts have already, using their own, provisions of the law, practice directions, were issued last year, and courts are already conducting virtual proceedings. I mean, I patronize the ECOWAS court in Abuja here. Since July last year, that court has not conducted any physical hearing. And it is the same with our court. Now, it's only when a lawyer objects that the court may say, okay, you can come for a physical hearing. So you don't need to go and put that in the Constitution. When you look at other areas, you ask yourself, what do these men and women in the National Assembly think they are doing? Is it about addressing the problems confronting the country? And we cannot make this a regular phenomenon. You must embark on a holistic amendment of the Constitution, a holistic review. Because what they are calling the Constitution, the 1999 Constitution, is Decree number 24 of 1999. Constitution of Nigeria, promulgation, Decree number 24 of 1999, signed by General Abdulsalami Abubakar. So it's not our Constitution. So what is the problem with saying, let all interest groups be given the opportunity to put their demands across? We then write a Constitution of Nigeria, which should be enacted and made by the Nigerian people. But how can you be amending a military decree and you are deceiving Nigerians that we are amending the Constitution of the country? So, but if they agree, if the dominant section of the Nigerian ruling class decides, we are not going to have a holistic review. What we want to do is occasional, instrumental amendments. But at the end of the day, what do these amendments amount to? Do they address the problems confronting the country? Do they address the question of patriarchy? And that is what you have seen. And how can you in this age and time say that women should not be given slots or seats in the parliament or slots in the executive branch of the government? It's unacceptable.
Thank you so much, Mr. Femi Falana. I'd like to have your take as regards another contentious issue, the VAT issue, vis-a-vis the fact that that case is currently in court.
Now, it is clear to all and sundry that as the law stands today, it is not the business of the federal government, because it is not in the exclusive legislative list, collection of VAT. And therefore, the federal government cannot insist that it will retain the status quo. And that came out. Why do you want to continue to concentrate more powers on Abuja, which is already overburdened, right? And I think that came out because they know it's not going to work. So, and that is part of the demand of our people. Let us run the country in a way that each state can engage in economic affairs. And at the end of the day, you pay some tax to the federal post and not the other way around. Because if you must know, the VAT, for instance, section 4, a section says 4% of the total VAT collected, will be retained or deducted and retained by the FRS. All the custom duties in the country collected, 7% will be deducted by the customs board. And you ask yourself, where is this coming from? Well, this is part of the legacy of military dictatorship in Nigeria, that we must now sit down. Who is taking what, from where, and for what purpose? So, and that's what I mean. The economy was not addressed in the whole amendment. Nothing serious about the economy. The VAT thing, a court has already ruled that this is not the business of the federal government. So an attempt was then made through the constitutional amendment to overreach the court. But I think majority of the members felt no. We should not concentrate more powers on the center, as it is the case now. But again, as I said, when you look at all the amendments, none has addressed the question of official impunity, which has made a mockery of democracy in our country. Take, for instance, you have the Niger Delta Development Corporation. the law provides that that body shall be headed by a board. That board will be peopled, constituted by representatives of the Niger Delta oil-producing communities in Nigeria. But what has happened? You have a minister with the backing of Abuja. I'm talking of the minister of Niger Delta, who is a lawyer, by the way, a senior lawyer, running the place with the appointment of interim administrators, caretaker committees, or even now, a sole administrator, contrary to the provisions of the law. Now, you can't justify that in a democracy. Right now, I have 3 gentlemen who were just released yesterday. They were detained on the orders of a general in November last year, November 29. And we have done everything to get them out until we had to go to court. In January this year, January 10, in Ibadan, your state, a Nigerian, I think Aziz Akintunde, was ordered to be released by a court of law. Up till now, the general detaining him has not released him. 2 days ago, or last week, a village in Imo was invaded by policemen. And what happened? A village in Izul local government. Some criminal elements burned down 2 police stations. The police descended on the village without looking for the criminal elements. The place has been occupied militarily. Houses have been burnt. About 15 people have been detained, including a woman who went to serve food, who went to give food to her husband. So you can't run a democratic society this way. And the National Assembly members are not asking these questions. All the laws we are making, all the amendments we are making, are they going to work in an environment that is hostile to the rule of law?
Mr. Falana.
Take the one, very interesting, that people are celebrating. The idea of lifting part of Section 18 of the Constitution in Chapter 2 to Chapter 4, i.e., compulsory education, basic education. As far back as 2009, the SERAP obtained a judgment in the ECOWAS court that every Nigerian child shall be educated free of charge by the state. In, I think, 2014, Leopard, another NGO, obtained a judgment in the Federal High Court based on the provisions of the Child's Rights Act, the compulsory, free and compulsory, free and universal basic education act. Every child shall be educated from primary to junior secondary school level. These 2 judgments have been disobeyed all over the country. Right now, Dr. Ruben, 51 billion naira has not been accessed by state governments to promote basic education in all the states. So, without addressing the culture of impunity in our country, you cannot talk of amending the Constitution without seriously tackling the question of impunity. And this is our terrible experience.
Okay, Mr. Falana, my first question, which I posed to you, there was a second part to it, which has to do with the essay you wrote on making Chapter 2 of the Constitution justiciable. And in that essay, you refer to Section 17, under which you were talking about legal protection for women. And in this particular instance, we've seen that, look, women were just disregarded. 35% affirmation in terms of cabinet representation, 35% representation in political party leadership positions, the right of spouses, foreign spouses of Nigerian women to be recognized as Nigerians, the indigenship rights of women who have been married to a man in any particular part of Nigeria for 5 years. But in the same essay, you argued that those rights are already covered under Chapter 4 of the Constitution. But you still insist that, look, the whole of Chapter 2 should be made justiciable. I wanted you to provide a linkage between that, your submissions in that essay, and this one.
Yeah.
Okay,
Yeah,
I'm told
my
we need to
position
go,
is that-
Mr. Falana, I'm told we need to go on a short break. After the break, we can then take your comment on that. We take this short break and then we'll be right back. Stay with us. We'll be right back. Welcome back to the morning show here on Arise News. Our guest is still Femi Falana, senior advocate of Nigeria, popular social critic, and civil rights activist. Mr. Falana, thank you for staying with us. Well, I asked you a question about your essay on Chapter 2 and current developments with the alteration, the fifth alteration of the 1999 Constitution.
Yeah. My submission, the program organized by the SPIDEL of the Nigerian Bar Association, is that following the decision of the Supreme Court in the case of Attorney General of Ondo State and Attorney General of the Federation, the National Assembly is empowered to actualize the provisions of Chapter 2 by making laws to advance the cause of our people. And you have had such laws like National Minimum Wage Act, the Pension Reform Act, UBEC Act, Child Rights Act, even the NDDC Act, and the rest of them. And I'm saying it is not enough to make laws. It is not enough. It's not sufficient to make Chapter 2 justiciable. If you have a ruling class that has absolute contempt for the rule of law, constitutionalizing the provision of Chapter 2 will be meaningless. And that is what we have seen. Where a senior lawyer heading an agency like Mr. Godwin Akpabio, heading the Ministry of Niger Delta, will allow the NDDC to be run by sole administrator contrary to the provisions of the law. Or you have a situation whereby since 2004, all children of school age should be educated by the state. But today, we have about 16 million out-of-school children. And that is the highest in the world. So once you are not committed to democracy, to the rule of law, there's no amount of constitutional amendment that will change the living standards of our people. And that is my point. Whereas there are laws that have been made pursuant to Chapter 2, these laws are being disobeyed by a government that loudly proclaims to operate under the rule of law. This is my position. Take the question of security. How can the National Assembly say you are opposed to state or regional police when we already have state police in Nigeria? In the southeast, you have what you call a Buleagu security network. In the southwest, you have Amotekun security network. In some part of the northwest, you have Ishba security corps. In the northeast, you have the civilian JTM. Some of them are armed to the teeth. They are arresting people. They are having them prosecuted. And then you still deceive yourself that we shall continue to have only one Nigerian police force. Meanwhile, at the federal level, you have created the Civil Defense Corps. You have empowered other agencies like the Prisons, Correctional Center Service, the EFCC, the ICPC, Customs, and the rest of them. Their officials, they are now allowed, their personnel are allowed to bear arms. And here you see saying, we are not going to have safe security. The fear should have been addressed, i.e., state police may be used by governors, to protect themselves or to harass their opponent. Now, why don't you have a situation where we are going to say, for the police council in every state, these are the organizations that shall be represented. That's all. But to say we should continue with this state of insecurity in our country and that the status quo be maintained, I even wonder, with profound respect, whether the members of the National Assembly have also familiarized themselves with decisions of our courts in respect of, which have bearing on the amendment. For instance, in the case of Alhaji Atiku Abubakar and the Attorney General of the Federation, the Supreme Court made the point that in Nigeria, the Nigerian police force shall be neutral because it's not an agency of the federal government. The same position was maintained by the Court of Appeal in the case of Agagu and Mimiko, whereby the State Security Service and the police and INEC were meant to appreciate that you are federal agencies, not agencies of the federal government, and that therefore, being agencies of the federation, thou shalt protect the interests of all Nigerians and groups equally. So you cannot allow yourself, like the State Security Service, calling itself Department of State Security in the presidency. Who gave you that name? Is that the provision of the law setting you up? Meanwhile, when you sue the State Security Service in court, as Department of State Security, there is an objection which should be upheld. So why are you calling yourself Department of State Security in town? So these are issues that have been settled by our court. Yet, the National Assembly pretends that it's not aware of this decision. And so you want to retain the status quo of impunity, of lawlessness, executive lawlessness, and sometimes of legislative rascality. That is what our democratic culture is teaching.
Okay,
that
sir.
is what is being advanced.
Okay, sir. Okay, sir. Let's talk a little bit about the hypocrisy as regards the insecurity problems in Nigeria. And the line is, a lot of governors will say, oh, they say we are the chief security officer just in name because we can't really do anything with the police. But why is it that it is so easy for these same governors to collaborate effectively with the police when they want to fight their political opponents? That's one. Number two, do you think that passing, bills that would whittle down the power of the executive? So take, for instance, if it had passed, removing immunity from the president, for instance, will change things. Because a lot of people have advocated for sort of like a shock therapy. That if the executive gets a shock therapy and knows it's not that powerful, then maybe things will start to change.
It is not correct to say that governors are helpless when it comes to securing their state. Again, there are decisions of our courts on this. In the case of Attorney General of Anambra State and Attorney General of the Federation, and this occurred during the time of Dr. Chris Ngige, while he was governor of Anambra State, and President Obasanjo withdrew police powers from him. He went to court, and the Supreme Court made the point that by virtue of Section 215 of the Constitution, the governor of a state has the power to give directive to the commissioner of police in that state when it comes to maintenance of law and order. That is the position today. In the case of IGP and AMPP, the Court of Appeal said, affirming the decision of the Federal High Court, that the name of the IG is not even mentioned in the Public Order Act. Therefore, all rallies in a state all public meetings in a state shall be controlled by governors of the state. You have a station today where a governor wants to have a rally. He will apply to the commissioner of police or to the IG. Now, I can go on and on. In terms of the way and manner, our courts have promoted what I call restructuring by litigation. Now, when you say you are helpless, but when it comes to harassing your political opponents, you are not helpless. The Constitution, this current Constitution, provides that the Nigerian police force shall be administered, organized, and supervised by the Nigerian Police Council. The Nigerian Police Council is constituted by the president, the entire 36 state governors, the Inspector General of Police, and the chairman of the Police Service Commission. So you have 36 members out of 39 who are the chief executive of the states, chief executives of the state. What happens at the end of the day? That body never meets. A body that is supposed to administer and supervise the Nigerian police force. We mounted prayer on the National Assembly, I think in Section 6 of the Police Establishment Act 2020. It is clearly stated that that body shall meet at least twice a year. The law came into force last year, September. Up till now, there has been, September 2020. Up till now, there has been no meeting of the Nigerian Police Council. So the governors have abdicated police powers to the president. And so you now have a situation today whereby the president and, the Police Service Commissioner and the Inspector General of Police run the Nigerian police force, contrary to the stipulation of the Constitution. So when you look at it, you ask yourself, what on earth is going on, with respect to the amendments that are being carried out. And by the way, please, and this is, Nigerians must not celebrate any of the amendments here, because all the amendments are going to the houses of assembly in the 36 states. And if any of them is not supported, is not backed by the resolutions of 24 houses of assembly in the states, that will be the end of the matter. So there's no cause for celebration yet, even for the minimal, success that may have been recorded this time around. And the governors, as you well know, also wield a lot of influence in the houses of assembly.
Well, Mr. Falana, you cannot be more correct on that score. This is just the beginning, and the process may even take a much longer time than we expect. But if we stay at the level of principles, there were certain issues that House considered, beyond the points you've made about process and impunity and rule of law and all of that. Take, for example, independent candidacy was endorsed. Is that the kind of thing you would like to see go through? Diaspora voting was rejected. Do you think that that's an error on the part of the lawmakers? And now, in the view of the lawmakers, the office of the Minister of Justice and Attorney General of the Federation, the lawmakers are recommending that those two offices should be separated. The same thing with the office of the Accountant General of the federal government and Accountant General of the Federation. The Bill 17, is also supposed to create a Federal Revenue Court and also a Revenue Court in the states. Are there some positive sides of what has been proposed that you would like the states, 24, we need 24 of them, to support, including the fact that states now can control railway, they can control their own electricity processes as proposed by these lawmakers? Can we dwell on some of the positive sides beyond the general framework?
Well, again, I think what the National Assembly has done is perhaps to formalize or constitutionalize existing developments in the country. For instance, aviation and airports are in the exclusive legislative list, whereas the federal government has not been able to revive the Nigerian Airways or set up the Nigerian Air. Akwa Ibom has one of the best domestic airlines in Nigeria today as a state. Akwa Ibom, Anambra State, Delta State, and Imo State have their own functional airports. So this is a situation where the federal government was compelled to cede powers to those states that are willing to fund development in their states. And that is the explanation. I mean, and it's not that states are being given the responsibility to control railway and electricity. It is that these matters are transferred from the exclusive legislative list to the concurrent list so that state government can invest in them. And so the federal government will have no power, just like it did in the case of Lagos Aaron project, to say whatever electricity you generate shall go to the national grid. What they are now saying, is that you can retain the grid, whatever you have generated without transferring them to the national grid. That's not anything really new, because if I've invested in electricity, you cannot compel me to transfer them elsewhere, But on some of the names or titles, one, they have argued ad nauseum that you cannot talk of an accountant general of the Federation having any power on the state revenue. Now, that has now been agreed by the legislature. Yes, we shall have the accountant general of the Federation, because by virtue of section 162 of the Constitution, there shall be an account known as Federation account. So that Federation account cannot be managed by the accountant general of the federal government, going around being described as accountant general of the Federation. That is the point that has been made. There can be, again, I've argued, you cannot have an attorney general of the Federation when the states have their own attorneys general. You cannot have secretary to the government of the Federation when the states have their own secretaries to the government. You cannot have accountant general of the Federation, auditor general of the Federation, when each of the states have their own auditor general or accountant general. So it is not enough yet. They haven't gone far. We must now say, just like you have done in the case of accountant general of the Federation, the auditor general of the Federation now will limit his powers, functions, to auditing the accounts of the federal government, because the state government have their own auditor general, auditors general. The same thing with attorneys general. The attorney general of the Federation today can only enforce federal laws if there is killing anywhere. And that was the point I made in the case of the gentleman that was killed in Ife, whereby those who alleged to have committed the offense were brought to Abuja. I had to write to the Inspector General of Police. Every crime is local. You must go to Osun State to charge the suspect with murder. It's not a federal offense. And the IG did very well by ensuring that the case, has been transferred. I think the suspect has been arraigned today in Osogbo. Now, on the Attorney General, trying to separate the two offices, we got this idea from the UK. Today, the two positions have been separated. Among the 15 members of the ECOWAS, about 10 have separated the two positions. Right now, Sierra Leone is trying to amend its constitution to have the two positions separated. So, there's nothing new in this separation. This is in line with developments in the country. For instance, how can you have the Attorney General of the Federation or Attorney General of the federal government swearing in, performing swearing in ceremony for the members of the ruling party who have been elected into office? No, that is not the function of the Attorney General of a country. So why the two positions are separated is this. And this is the argument we have made over the years. The Minister of Justice is a member of the cabinet to take care of the affairs of the judiciary, having adequate number of courts, the number of judges that are going to be appointed, and so on and so forth. But when it comes to the Attorney General, they call the Attorney General Procureur General in the Francophone countries, in West Africa. What the Procureur General, the Attorney General does, the Attorney General is, by the way, is appointed like a judge, independent of the executive, either at the federal or state level, to prosecute all indictable offenses. So it's not going to be controlled by the president or the governor. It represents the public interest, unlike the mockery that we make of that office now. And I think this is what is being recognized. This is the call over the years. And this is not the first time this recommendation has been made. It was defeated in 2014. We hope it won't be defeated this time around.
Okay, well, I mean, so many other issues to still talk about, but we'd like to thank you very much, Mr. Femi Falana, SAN, for joining us on the morning show to shed more light on the fifth alteration process of the 1999 Constitution.